Thank you. You may be seated. We are here on the matter of State of Ohio versus Donald Kopchak, case number 25CR0520. Mr. Kopchak is present in court with his counsel, Attorney Spellacy. We're here today to impose sentence pursuant to a jury verdict which was adopted by the court of guilty of 2 counts of abduction, each felonies of the 3rd degree, 1 count of ethnic intimidation, a felony of the 5th degree, and 1 count of assault, a misdemeanor of the 1st degree. Present on behalf of the state of Ohio is
Mr. Salisbury. Both, Judge.
All right. Attorney McNamara and Attorney Salisbury. Mr. Salisbury, are you speaking on behalf of the state?
Yes, Your Honor.
Okay. Do you have any recommendations?
Yes, Your Honor. You heard the trial, so there's no need to belabor the facts. This, as I said in the Mr. Lajak sentencing, this is a crime that kind of divided the community. Very impactful. We believe the jury got it right. And quite frankly, as the court shall recall, didn't take a very long time to deliberate even. The impact on the victim was great. And although that impact was so great, he still to this day is saying, he doesn't want see anything bad happen to these 2 guys. Which is, kind of amazing to me, considering what he was put through that day, both physically and mentally now, as you heard his testimony. The defendant in my mind has still not taken responsibility, although he does say he does never deny doing anything. I don't believe that's true. You'll recall his testimony. I don't believe he did admit to all the physical aspects that he did to the victim. But, you know, I'm not saying he sat there and denied doing anything. He didn't. And again, he thought he was justified in doing so. That belief was clearly wrong, and is clearly, found by the citizens of Medina County, not to be tolerated. Judge, this was, a clear case of ethnic intimidation. We believe a prison sentence is appropriate, and we would leave that length of which in the court's discretion.
Okay, I know you're illegal.
All right, let him go. You stay on the ground. Stay on the ground.
Oh, okay.
Just sit there.
Yes. They don't let me call police. They took my everything. I'm good. I'm legal. Everything. This is my ID.
He's from Israel. Yeah, Texas ID. Came in. Yeah.
Where do you live, partner?
I'm living Fort Worth, Texas.
You live in Texas?
Fort Worth, Texas, yeah.
Okay. What are you doing in Ohio?
I'm coming to work.
Work where?
Where am I?
Yeah, where do you work?
I'm truck driver.
Where's your truck at?
I just park it in.
Where?
On the company. I have delivery for Monday.
Okay.
So I'll be here, and I have to go to the motel. When I'm coming here, these 2 guys, when they see me, they ask me like a lot of things, and they take my ID. Why you here? I don't know why. He just take me my hand like this, just like I don't know why. I'm trying to call police. He took my phone, everything. These 2 guys, they ask me a lot. You are not supposed to be here. This is fake ID. I'm not fake. I'm legal in the United States. I've been here 14 years. I'm citizen.
Like, I told these guys, like, over here, I go, guys, you're off duty. You're in a bar drinking. What are you doing?
They fall down.
A Cleveland police detective, Donald Kopchak, was found guilty of abducting, assaulting, and intimidating an innocent truck driver because of his national origin. The victim, a legal U.S. citizen from Eritrea, was simply waiting before work when 2 off-duty officers accused him of being illegal, took his phone and wallet, and forced him to the ground.
Mr. Spellacy.
Thank you, Judge. Also with me is Lewis Group, Your Honor, and Ms. Hanson is also sitting back there. Judge, obviously I filed a sentencing memorandum with you on June 9th. I believe I'm confident the court got it, read it. There's some great letters attached. I think they describe Don very, very accurately and very well. This is a tragic situation, obviously, for everybody. And I would disagree with Mr. Salisbury that my client he testified to what he did. And we can go over the spilt milk, so to speak, but there wasn't a justification instruction. There wasn't an expert report that was submitted. But that's for a different day, Judge. But I think that could have changed the outcome substantially. Judge, I could just say that in the brief, he's a father. He's a good father. He was a coach. He was a good coach. He was a police officer. He was a good police officer. And I think a lot of these people behind me would support those contentions, Judge. He's been in jail 82 days. They have not been an easy 82. I think the pre-sentence report indicates his likelihood of recidivism is at a score of 1. So I don't think that we need to protect the public from him. And I think the odds of this happening again are extremely unlikely. Judge, I think all those things speak to a community control sanction, and that's what we're asking you to do here. Thank you.
Thank you. Mr. Kopchak, what would you like to say on your own behalf?
Yeah, and I just want to go off exactly what my lawyer just said, that I never denied anything. I took the stand and I was honest. And that's what I was told to be. I was told to be honest by my lawyers and my union, and that's what I did. I sat there and I was honest, and never in my life did I ever think that I would be here sitting in front of a judge like this. And that's not the type of person I am. And those letters and everything that are put in front show that what I've done in my life and what I've would continue to do when I'm out. And on behalf of my lawyers and everything, I was advised to keep this to basically that.
All the letters in support. The thing that the letters in support don't discuss is the effect of your behavior on the victim in this matter. And so my focus is not on whether you're a good person. I'm sure you're a fine person, but on your behavior and the impact that had on the victim. And so after consideration of all the relevant factors set forth in the statute, and also the information contained in the pre-sentence investigation report, it is the sentence of this court that on count 1, a felony of the 3rd degree, you will have 18 months in prison. On count 2, also a felony of the 3rd degree, you will have 18 months in prison. On count 3, a felony of the 5th degree, you will have 10 months in prison. And on the misdemeanor of the 1st degree, you will have 120 days in jail. Your time will run concurrently and not consecutively. Upon your release from prison on counts 1 and 2, you will have a mandatory period of post-release control of between 1 to 3 years at the discretion of the adult parole authority. When this period of post-release control is imposed, if you violate the terms of that supervision, the adult parole authority is authorized to return you to prison for up to 9 months for any single violation, up to a maximum of 50% of your prison term for all violations. If while on post-release control you are convicted of a new felony offense, in addition to being punished for the new offense, the judge could add an additional consecutive prison term of 1 year, or whatever time remains on your post-release control term, whichever is greater. As you will be incarcerated, all fines and costs will be waived. Also, on count 3, the felony of the 5th degree, you may be subject to a period of 2 years, possible discretionary post-release control. I also need to notify you of your appellate rights. You have the right to appeal the conviction or sentence in this case. You do that by filing a notice of appeal with the clerk of courts for the Court of Common Pleas within 30 days of this sentence.
I'm going to make an oral motion for a stay of the sentence on behalf of Mr. Kopchak. There are a couple matters with respect to that. For a stay motion, there are basically 2 considerations. The first is the same kind of bond considerations the court would normally consider when releasing somebody pending a trial. I'm going to defer to the court on those. There's already been a personal recognizance bond. If this is granted, that would be appropriate. I have no reason to believe that there's anything that's changed, simply because Mr. Kopchak has been convicted. He's the same person before you. Same family, same considerations. He's not a flight risk. As to whether or not a stay should be granted, the general standard applied by the Court of Appeals across the state of Ohio is whether there's a reasonable argument for appeal. The court referenced numerous times in the transcript, which I've now read in the last couple of days, that there could be an appeal, likely would be an appeal. There were a couple issues. I'm happy to address the specific issues pending appeal if the court would like to get into that. But I think that given all that has happened, it's probably safe to say the court understands the issues from the trial, and we would just say that there are reasonable grounds for appeal. Coming out of today, if the court could issue a ruling on this in writing in the sentencing entry, that could avoid a written motion, but I'm also happy to brief it in writing for the court. It's up to the court. Please let me know what the court would prefer from me going forward from here, but that's the motion. And thank you for your time this morning for that.
Thank you. Your oral motion is denied. Your client has filed motions with this court in which he has indicated that he would prefer to be in prison rather than remain in the Medina County Jail. And so I am going to grant him his wish and let him go to prison at this time.
May I be heard on that, Your Honor?
No.
Okay, thank you.
Thank you. Anything else on behalf of the defendant?
No, thanks.
Anything else on behalf of the state of Ohio?
No, Your Honor.
Okay, thank you. We are in recess.
During the sentencing hearing, prosecutors said the victim still suffered emotional trauma, while the defense asked for probation, arguing Kopchak had been a good father, coach, and police officer. Judge Joyce Kimbler said the case was about the harm caused to the victim, not the defendant's past achievements. She sentenced Kopchak to 18 months in prison, explaining that a police badge gives authority only within the law, not above it. The judge also denied his request to remain free during the appeal, making it clear that no one is above the law.